We hold regular workshops throughout the year, and you can check our website for more information. Today, we're glad you're here with us. My name is Crystal, and I'll be today's host. Our speaker is Managing Partner David Miller, but before we start, I'd like to point out a few items. This is being recorded, so you can turn off your video camera if you have it on, or if you can keep it on, if you'd prefer. We will ask you to remain muted throughout the presentation. Please utilize the chat feature that's in the bottom middle of your screen for any questions. We'll answer those at the end. And there's also a survey being sent out directly afterwards that will allow you to input any ideas for future presentations or set up a free consultation with us if you desire. So at this time, I'm happy to turn your attention to Mr. David Miller.
Okay. Thank you very much, Crystal, and thank you everyone for being here today. Good afternoon. My name is David Miller. I'm a partner here at the firm of McCulloch Miller. Just a little bit about me. This is actually my second career. My first career was in finance, where I started as a broker and then went into investment banking. But I've been practicing law for over 11 years, and we have an estate planning and probate firm. And part of our estate planning process is we're meeting with clients all of the time. And one of the things I ask a new client is, how concerned are they about avoiding probate and the probate process? And what I've found throughout my time doing this is a lot of my clients, they just don't really know what I'm asking. They don't really know very much about what the probate process entails. They might have also had some horror stories about the probate process. This was really even driven home for me recently with the passing of somebody in my family, where I'm working with my parents and my aunts and uncles to probate the estate of my grandmother. And my aunts and uncles are smart, accomplished people, but they've never been through this process before. And like so many people that are dealing with probate, they're dealing with it for the first time. And they don't know exactly what they can do, what they can't do, what they should do. They don't know the steps of the process. And so really what I've done with this presentation is we designed this presentation to kind of give you an overview of what probate in Texas looks like. Talk about who the players are, what's the difference between if you have a will and if you don't have a will, talk about the steps involved, and then we'll talk a little bit about some of the pitfalls with the probate process and touch a little bit on some of probate avoidance strategies. So the first question here is, one moment, having technical difficulties. The first question is, what is probate? Probate is a judicial process of distributing the assets to the heirs of someone that has died. So what does that mean? Probate's a legal process. It's going to be in front of a court, and it's going to be governed by the will, if there is one, and it's going to be governed by the laws of the state of Texas. And more importantly, why is probate necessary? So probate is necessary because you can't actually do anything with the decedent's assets until you legally control them. So if you need to use their money, the money of somebody who's passed away to pay taxes, to pay insurance, if you need to sell property, or you want to distribute assets to the beneficiaries, you can't actually do any of that until the court has named you in control of the estate and bless the will or name the heirs. And a real world example of this, something that we actually come across on a fairly regular basis, is a situation where if you imagine a husband and wife, and the husband passes away and the wife continues to live in their family home, and she pays taxes and she pays insurance and she thinks she owns the house and her kids think she owns the house. And then you fast forward 10 years and she goes to sell the house. And they get a contract and they're going to closing, and the title company says, well, you can't actually close on this house because guess what? You don't own all of this house. This is a community property estate. You only own half of this house. The other half is owned by the estate of your deceased husband. And now you're in a situation where you have to jump through a whole bunch of hoops and you have to transfer title of that property to mom so that she can sell the house. And that's really kind of the pitfalls. That's how this sneaks up on somebody when they're not really thinking about what probate is, why they need to probate, and how they're actually going to legally pass control of assets from one person to the next. So The process in Texas is actually fairly simple and straightforward. I say we title this a simple probate process because there are a lot of complexities, right? There's a lot of legal requirements, there's some magic language, there's a lot of forms, and a will can be a very, very simple will. It can be a one-pager, or it can be a very, very complex will with a very complex estate that's 60 pages long. But the actual process itself is still fairly straightforward. Step one is the court is going to designate who is in control of the estate. And step two, the court is going to accept the will into probate, or they're going to determine who the heirs of an estate are. And then after that, the administrator is going to do the things that the Texas statutes require. That's filing an inventory of the assets, notice to creditors. They're going to pay the liabilities. They're going to take care of the taxes, and then they will distribute the remaining assets to the heirs. And is this hard to do? Not necessarily. If you have a good and solid, valid will, and it's kind of got the right magic language, this is fairly easy. It's actually pretty cheap to do it. Texas is a very forgiving state. And at the end of the day, if you have a valid will, it is a really just an administrative process. So as I go into what the more detail what the process looks like, I want to talk a little bit about the vocabulary. This isn't a law school exam, and there's not going to be a test at the end. But if you find yourself in the probate process, you're going to hear these terms thrown around a lot. So I want to talk about it. And there's two different scenarios that we're looking at. One is probate when you have a will, and the other is intestate succession, right? Which is you pass away without a will. And so who are the players that are involved? Well, the person that's died, that is known as the decedent. And that's whether you're in an intestate proceeding or a probate proceeding with a will. The person that controls the estate, if there is a will and the will properly names an executor, it's going to be the executor or executrix if it's a woman. If it's someone passes without a will, that's going to be the administrator. The next group is who are those that are going to benefit. If you have a will, these are generally referred to as the beneficiaries or devisees of the will. If you don't have a will, these are the heirs. And then there's another party here, which is the adversary is what we call them. And this is what happens when you pass away without a will. There is an ad litem appointed, and that is a court-appointed attorney who's going to be part of this process and who's going to help with determination of the heirs. So who, what, when, and why to probate? We already went through the why, which is you have to go through the probate process if you want to distribute assets that are in someone's estate. But when do you probate? Well, of course, you're going to probate only after someone has passed away. But importantly, if you have a will, you have 4 years to probate that will. If you wait more than 4 years, there's still certain things you can do, but it's more limiting and there's some more steps that you have to jump through. You're also only going to probate a will if there is something in the estate to pass, right? So if somebody is very, very poor and they have no money and no assets, then it really doesn't make sense to go through the time and expense of probating or going through an heirship proceeding when there's no assets to pass on to beneficiaries. Likewise, if someone has done some thorough estate planning, they might have all of their assets in a trust, which then means there's nothing left in their estate when they pass, and you avoid probate that way. Who is going to go through the probate process? Well, technically anyone can file an application, but typically when we're working with our clients, it's typically going to be the executor or the person that the family has decided is going to be the lead administrator of the estate. But it's important to know that just because you initiate a probate proceeding, it doesn't mean that you're going to end up being in control of the estate and of the process. That's going to be determined by the will and by the courts. And then the next thing is, what are you going to probate? So here we're talking about the assets in the estate. And the big one that we deal with day in, day out is the house. It's real property titled to the decedent, all right? But there's other types of assets that you got to think about. If say a spouse, she starts her own business and maybe it's a single member LLC and she owns the shares of those business, That's going to go to her spouse, but you have to probate that so you can actually transfer the shares. Personal property, artwork, jewelry, furniture that's in the house, that's going to have to go through probate. Certain financial assets that don't pass by some sort of beneficiary or pay on death designation. So if a husband passes and he has a savings account that's only in his name, or the wife passes and she has an investment account that's only in her name, those are going to have to go through probate. And finally, another one that people often don't think about, it's a little intangible, is lawsuits. We actually have a client right now who, when he passed away, didn't have any assets to pass to his beneficiaries. Unfortunately, though, he was a victim of a wrongful death, and now there's a wrongful death suit. But guess what? You can't actually bring something like a lawsuit on behalf of somebody that's passed away until a court has named you the proper party to do that. So again, you have to go through the probate process to get that authority. So what does this process look like? Well, first, we're going to talk about the process of probate when there is a will. And to do this, we first have to look at what makes for a valid will. And the answer is it's not that much. The qualifications for a will are pretty low, but generally you have to have capacity. You have to be at least 18, although there are exceptions if you're married or in the military. There's got to be a written document. And there's two types of written documents that we look at. First is the holographic will. This is a handwritten document that's all in the testator's handwriting, the testator being the person actually making the will. This holographic will is kind of what we think of when we think of a will on the back of a napkin, right? The other type is an attested will. This is a will that you're going to get if you go to an attorney's office or use LegalZoom or something like that, which is going to be a typewritten document that is signed by the testator and witnessed properly by two people over the age of 14. Okay. And if you have a proper will, what it's going to do, it's going to name the independent executor. It's going to name the beneficiaries. It's going to have certain formalities in it that are required under the state of Texas, and it's going to be signed in a way that's required by the state of Texas. And if you do that, what you end up with is a valid, what we call self-proving will. And if you have that and you have to take that through the probate process, we really are talking about a very administrative process, and it's pretty simple. And what that process looks like is it starts with an application to the court. Then you have to get the will into evidence, and you do this by sending the court the original will and then having a hearing on the will. The court will then admit the will to probate. The court will appoint the executor, and then they will issue the letters testamentary. Once you have the letters testamentary, that really is a turning point in any probate case, because that is when the executor can then take those letters and they can talk with the banks. They can sell property and sign, with the title company that they're acting on behalf of the estate. They can bring a lawsuit. They can negotiate with debtors. That really, those letters testamentary, what empowers an executor to do the things they need to do to administer and then distribute the estate. Then there's some things that are required by statute. So you have to file an inventory of the assets. You have to do a notice to creditors. There's some other administrative things like doing the taxes on the account, collecting the liabilities and dealing with creditors of the account. And then finally, when it's all done, they make the distributions of the estate. Again, it's a pretty administrative process if you have a well done and valid will, but there are some pitfalls, right? And if the will is not properly done, it can create some issues. And those issues can be as minor as not signing it correctly or having a problem with the what we call self-proving affidavit. If that happens, well, you can generally rectify that fairly easily, but you're going to have to call additional witnesses to do what we call prove up the will. That's the process of getting it into evidence. There might be an issue with the way the executor is named. And so you might end up with something called dependent administration. They need to post a bond, and that can be more time consuming and more expensive. Then other things can happen with a will that's not properly done or not updated to deal with changed circumstances. And that can result in the assets and the beneficiaries don't align with the intent of the will. And I'll give you an example of what can happen here. Imagine a widow who has about $500,000 and she has 2 kids and she wants to make some gifts to 4 different people. So she names $25,000 to 2 different charities. She gives $25,000 to her grandchild and then $25,000 to her brother, who she loves very much. And then says the rest goes to my children to share and share alike. And so when she writes that will, what she's thinking is, hey, $100,000 is going to go to these 4 people. And then my 2 daughters, they're going to share 400,000 between them. They're each going to get 200,000. But if we fast forward in time and the will hasn't been adjusted, and the will doesn't anticipate changed financial circumstances, what happens if her financial situation has changed? Maybe she fell on hard times or had a lot of medical expenses. And when she passes, the estate only has about $110,000 in it. Well, then under a will that hasn't been properly done, hasn't been reviewed, what might happen is those 4 other individuals are going to get their $25,000, and then the 2 daughters are going to be left with $10,000 left to split between them. And that's clearly not what the intent was. And that is how issues of probating a will can kind of go south when the change in circumstances, change in assets, change in beneficiaries aren't either anticipated in the will or the will is not updated. And finally, the worst thing that can happen with a will is it just fails. The court rejects it as a will. And while the bar for having a valid will is very low, we have had a couple of situations in our firm where we've taken a will to the court and the court simply says, this isn't a valid will, we're going to reject it. And that is when you get into probating without a will. That's when you pass intestate. And so this process is a little different than probating with a will. What does an intestate probate process looks like? Well, it's going to be driven by the court. And the court is going to determine a couple of things. First, they're going to determine who the heirs are, who's going to benefit. They're going to determine who controls. They're going to appoint the administrator. There might be some other considerations that they make, but most importantly, all of this is going to be governed and dictated by Texas law. And so if we look at this process, again, it's very similar to the process of probating a will, but there's some additional steps and there's some additional places where problems can occur. So like probating a will, it's going to start with filing an application. Then the court is going to appoint the ad litem. This is the court appointed attorney who's actually going to do the research to make sure the court knows who the proper heirs are. So they're going to talk to the applicant, they're going to interview witnesses so they can confirm the family tree of the decedent, and eventually they'll report back to the court. And then the court will appoint the administrator. That is something like the executor, but they're the person that's going to be in control of the estate. Who the administrator is and whether or not they get to act independently of the court or under dependent administration is really going to depend on who the players are, how the family gets along, other factors. In a best case situation, all the heirs will agree that one person shall be an administrator and the court will grant them independent administration. Worst case scenario, nobody trusts each other. There's a lot of animosity and the court says, well, we're going to appoint someone completely random. We're going to appoint another attorney to deal with this estate. And that can be very costly. That can be very difficult. Once the administrator is appointed, the court's also going to determine who the heirs are. And then after that, the administrator is going to receive the letters of administration. That's very much like the letters testamentary, and that's what's going to allow the administrator to do the things that need to be done for the estate. That is, selling property, collecting assets, dealing with debtors, dealing with the taxes. And finally, they're going to do the other things they're required to do, filing the inventory, the notice to creditors, and making distributions. So this process, it can be fairly simple, right? We have had certainly many clients that have gone through an heirship proceeding without any issue. We represented one daughter whose father passed away. He passed away without a will, and we were able to go through this whole process with just a little extra time involved, a little extra effort, and a little extra expense. But at the end of the day, it went smoothly, and it was no problem. But that is not always the case. There are any number of complexities that can happen. You can have multiple heirs. You can have multiple heirs that don't get along. You have different types of property, community or separate property. You can have blended families, and that can add all sorts of complexities to this process and really slow it down and make it much more difficult. So just as an example, what I said is this whole process is governed by Texas law. So Texas law is going to say who inherits. And there's a number of different scenarios. So in this one chart, what you see is if somebody is married and all their community property goes to their spouse. If they have separate property, some of that property goes to their children, other goes to the spouse. If it's real property, there's a different scenario where the spouse only gets a life estate and then goes to the children. And there's all different types of situations. It's going to determine on who are the survivors, are there children, are there children that have predeceased you with grandchildren, are there siblings, are there half brothers and half sisters, are we talking about community property or separate property? And it gets very complex. Each one of those that I just flipped through are different scenarios about who would inherit under Texas law. And the result of this is there can be some severe unintended consequences. One of the main consequences is the wrong people inherit. You might have a child that you're estranged from, or a half brother that you've never met and never talked to, but under the laws of intestacy and intestate succession, they are going to inherit. And so the wrong people have been included in your estate. You might have intentions to give to charity or to give to a niece or nephew, but under the laws of Texas, they're going to be excluded from that estate. So you can end up in a situation where the wrong people are getting money, or maybe they're getting the wrong amount. Maybe you have 3 children you want to provide for, but for any number of reasons, you don't want to treat them equally. And that's not going to happen under Texas law. Another thing is the process itself is just more difficult and expensive. Like I said, if it goes very smoothly, it's only slightly more difficult, slightly more expensive, but we've had cases that have cost thousands and thousands and tens of thousands of dollars and gone on for years, and they're still not done because of the complexities and the problems within the family dynamics. You can also end up with the wrong person in control. The court is going to name who the administrator is, and sometimes courts get it wrong and they'll end up naming the incorrect person. There's other issues that might be at a concern. You might have heirs that have supplemental needs issues or need asset protection, and heirship is not going to provide for that. But ultimately, like I said, Texas is a fairly forgiving place, and there generally is a legal solution to any problems that arise. And if you have a will or a very simple estate with a very simple family dynamic, again, Texas is a pretty administrative process. So let's talk about probate avoidance and why people want to avoid probate. And so you might say, well, David, you said if I have a valid will, and then the process is pretty simple, pretty cheap, pretty efficient. It's just an administrative process. Why would I worry about avoiding probate? And there's a bunch of reasons. The first is time. A probate process takes time. At the fastest it could possibly go, you're looking at 3 months, but we have cases that have gone on for more than a year. And what can complicate that? There can be complexities in the estate. There might be people that need to be served. You have difficulty tracking them down. What happens when COVID comes in and the court shut down for 2 months? Any number of things can delay this process. And what happens during that delay? What happens if your heirs need cash from your estate to preserve, like, the house and pay the taxes and pay the insurance? What if they want to sell the house today in Houston, where we have a really hot market, and they don't want to lose out on that market and have to wait a year before they can sell the house when the market might have cooled off. So there's a time component that can create concerns. There's the expense. In probate process, while in Texas, it's a lot cheaper than doing it someplace like in California or New York, it's still not free. Depending on what you're doing and the issues involved, it might be anywhere from $1,500 to $5,000 for an uncontested probate or heirship process. The ad litem, if you have to go through the heirship process without a will, they're going to charge, and that's going to be another $500 to $800. If you get into contested matters, then the legal fees really start to accumulate. But there's other issues. What if multiple probates are needed? So for instance, if you pass away in Harris County, that's where you're going to probate your will. But if you have a vacation home in Florida or a fishing lodge in Louisiana, you might be required to do what we call an ancillary probate in that state for real property that's located in that state. The other factor is if we're working with a married couple, unfortunately, death is inevitable. And if you have a married couple, that means you're ultimately going to end up with two different probate proceedings, each one costing their own time and expense. The next reason is privacy concerns. A lot of people are concerned about probate because it's all public. We're going to file the will. All the court proceedings are going to be public. The inventory is going to tell the world what the assets of the estate are. The will is going to tell the world who's getting those assets. A creditor claims might tell the world what was owed on the estate. And people can be very skittish about this. That might be because they're just very zealous about privacy and don't want to keep all of this in the family. There's issues of unwanted solicitations that come from all that public knowledge. If you file an inventory for a house, then you're going to start getting unwanted solicitations from brokers who want to list your house or investors that want to buy your house, and that is just a pain that you have to deal with. But also because you're talking about inherited money, that might make you a target for scammers and fraudsters. And so there are issues related to having all this information in the public. Finally, and this is one thing that I think a lot of attorneys don't really stress enough and don't really focus in on, is the emotional component of what happens in probate. Almost by definition, a probate's always happening at the worst possible time, right? You're generally grieving from the passing of a loved one. Tensions are high between siblings that might, love each other and love their parents, but have differences of opinion, and the stress level is high. There might be a need to do something very, very quickly, and adding the probate process onto that just really increases the stress for the beneficiaries and the heirs. So the question is there a better way? And the answer is yes. First, not surprising, you go into a webinar hosted by a lawyer, they're going to say work with a lawyer. But what can a lawyer actually provide? First, they can talk with you and review the will or draft a will to make sure that the will is clear, that's proper, that it comports with all the formalities required by Texas. They can go through your will and your estate plan to make sure the will that you have actually accomplishes your goals and matches with your assets and your beneficiaries. They can make sure the probate process goes faster, easier, and cheaper. And finally, if you want, they can help you find alternatives to the probate process. And there are a number of alternatives to probate. One type of vehicle that we use is trusts. We do a lot of revocable living trusts specifically for probate avoidance. And in fact, I believe on our website, there is another webinar that we talk a lot about trusts and how they work and how they can help avoid probate. But that's one tool in the toolbox. There's other tools. You might have seen the initials JTWROS on bank statements or on brokerage statements. That's joint tenants with rights of survivorship, which means when somebody passes away, the other person on the account automatically owns it. You have transfer on death designations. You have beneficiary designations. There's different types of deeds you can do to pass real property, like a ladybird deed. But all these are different probate avoidance tools, and working with an attorney can figure out which one works for you or which combination of these tools work well for you. So at this point, that really concludes our presentation on just the general overview of the process. I hope you found it helpful. We are doing another webinar on October 6th at 11:30, and that's going to be more in depth about the pitfalls of probate and how to avoid them. That's really going to look in depth at what can go wrong and what are the potential solutions. And finally, if you have any questions about this, or you want someone to look over your own estate plan or help you draft a will, then please contact us and you can have a free consultation with one of our lawyers to figure out what works for you for an estate plan. At this point, I will pass it back to Crystal to see if there's any questions from the audience. Crystal?
Absolutely. We do have a few. The first one being related to the wills. What if you designate percentages instead of like fixed amounts? Would that make it easier?
Yeah, that's definitely something you can do. I mean, there's lawyers, no one ever comes to lawyers for math, but there is some mathematical components that you can build into a will. So for instance, where I have a client that says, hey, I want to give $50,000 to this charity, I might say, I give the lesser of 50,000 or 10% of my estate. And so that you make sure that there are some safeguards so you don't end up with a very imbalanced distribution based on where the assets are at that time.
Okay. The next question are the fees that you quoted before. Are those Houston averages or those are firm fees?
Those are not our firm fees. Our firm fees kind of fall within that range. Those are generally Houston averages. That's based more on anecdotal than real market research, to be honest. But based on what I've seen, that's a pretty standard. And there's all different types of ways of doing the fees. Our firm does all probates. Unless there's a contested issue or some bizarre issue that arises, everything that we do is on a flat fee, which takes you from filing of the application all the way to what we call the drop order, which is when we consider the case done. Other firms will do it on an hourly basis. Some firms will do it on a flat fee to get you up to the hearing and then hourly after the hearing. So it really depends on the firm and exactly what their fee structure is. It should be noted that some states allow a lawyer to charge fees based on a percentage of the estate. So I saw some recent literature that said probating a $500,000 estate in California averaged about $13,000, which is much more expensive. In Texas, you're not allowed to do that. So it's got to be some sort of flat fee or hourly fee.
Okay. And the last one we have is, what if you don't have the money to pay for probate? Are there any other options?
Well, so that becomes, that's something you want to work through with the attorney that you're working with. There are, for very small estates where people don't necessarily have the money, there are, free legal resources. An attorney might get paid on the back end as opposed to getting paid up front. That's going to be dependent on the attorney and what they're willing to do and what they're willing to work with you. But it is important to note that the cost of probate is considered an expense of the estate. So if, for instance, you spent $3,500 out of your own pocket to do the probate, the first thing that happens is the estate is going to reimburse you for the expense that you paid out of your pocket before we start talking about beneficiaries and creditors and so forth. So it really depends on the situation, the type of the estate, the size of the estate, and what the attorney who you're dealing with is going to work with you on. Our firm typically get paid on the front end. But there are cases and situations where we do agree to get paid on the back end. It just kind of depends on the situation.
Okay, and that wraps up our questions for today.
All right. Well, thank you very much for your time. I really appreciate it. And if you have any questions, our contact information is on the screen. Thank you very much and have a good rest of the week.
Have a good one. Thank you.